Tonight, we revisit a case that settled itself into public memory. One investigation, one trial, one verdict that continued to be examined long after the sentence had been pronounced. The case of Clara Vance begins in Kingsford and the county of Northwell in the year 1875. The city of Kingsford at that period was the greatest metropolitan center in the kingdom, with a population approaching 4 million persons distributed across its historic parishes, boroughs, and the suburban districts that had expanded swiftly along the railway lines to the south and east of the river. The neighborhood of Ashburn, situated at the southeastern edge of the metropolis on the boundary of Northwell and Surrey Vale, was by the mid-1870s a settled community of artisans, tradespeople, and lower-middle-class families. Its streets of terrace houses connected to Kingsford Bridge and Victoria Square by a dependable rail service. Further south, in the chalk valleys of Northwell Downs, the landscape retained the character of an earlier age. The village of Fellbrook and the farms around it were accessible only by local roads unfit for rapid transit. The nearest railway station lay several miles away. The valley settlements were separated from one another by stretches of agricultural land, through which in the winter months passage was slow. The geographic contrast between these two environments, the accessible suburb and the remote rural valley, forms the physical framework within which the events of this case unfolded over a period of nearly 2 years. Clara Whitmore was born around the year 1841 or 1842. Her precise date of birth has not been established definitively in the historical record, and the sources treating her case are not uniform on this point. The age most frequently cited at the time of her death placed her at approximately 35 or 36 years old in April of 1877. Her birthplace is not firmly established in commonly available sources. She was the daughter of a family of lower middle-class or middle-class standing in England. Her father had died before the period in question, and her widowed mother retained an active and attentive interest in her daughter's welfare throughout the years preceding the marriage. Clara had inherited a capital sum and, in some accounts, an annuity. The precise figure of this inheritance was entered into the record at both the inquest and the trial that followed, but secondary sources have stated it inconsistently, with figures ranging from £1,200 to several thousand cited in different accounts. Whatever the exact sum, it represented a significant amount by the standards of the social circle in which she lived, and it constituted the direct and primary financial motive attributed by the prosecution to the man who subsequently pursued and married her. She had not been committed to any institution. She had not been made the subject of a formal lunacy inquisition. She lived within ordinary Victorian social arrangements under the informal oversight of her widowed mother, without the protections that formal certification under the Lunacy Acts might have afforded her. The language used in the contemporary record to characterize her intellectual condition was consistent across the inquest testimony, the trial evidence, and the national press reporting of the period. She was described as weak-minded or feeble-minded, terms that in the usage of the era designated persons understood to fall below the common standard of mental capacity, without having been formally adjudicated as persons of unsound mind. This position in the practical operation of the law was one of considerable vulnerability. She was presumed, in the absence of a formal finding to the contrary, to be a competent adult, capable of entering into a contract of marriage. The legal machinery available for the protection of certified lunatics did not apply to her. Her protection rested informally upon her mother's oversight and upon the ordinary expectations of her class and period. Clara's widowed mother had served in practical terms as her daughter's guardian in the years before Arthur Vance's appearance in her life. She was the closest person to Clara in any functional sense, and her subsequent testimony at the inquest and at the trial formed one of the most consequential strands of the prosecution's case. What she had been permitted to observe, and what she had been systematically prevented from confirming, would be placed before the jury in the autumn of 1877. Arthur Vance was approximately 24 years of age at the time of his marriage to Clara Whitmore in June of 1875. He was employed as an auctioneer's clerk, or in a related capacity, in the land agency trade. His precise occupation was entered into the trial record, though secondary sources describe it in slightly varying terms. He was a man of modest means, without any recorded prior legal history. The age difference between the parties was considerable. Clara was approximately 10 years his senior, a disparity in years compounded by the pronounced difference in their mental capacities that was remarked upon throughout the subsequent proceedings. His courtship of Clara had been conducted with a persistence that her mother observed and opposed. Her objections were grounded in her assessment of his suitability and in her concern about her daughter's capacity to give fully informed consent to the union. Those objections were not sufficient under the law, as it then stood, to prevent the marriage from being contracted. The marriage between Arthur Vance and Clara Whitmore was solemnized in June of 1875. With the marriage, Arthur Vance assumed the dominant domestic and practical position in the management of his wife's affairs that Victorian law conferred upon husbands. Clara's inheritance passed into the household over which he presided. Almost immediately following the ceremony, the pattern of his conduct toward her was one of exclusion and displacement. Rose Mercer was the younger sister of Helen Mercer, who had married Daniel Vance, the brother of Arthur. Her connection to the Vance family circle therefore predated her relationship with Arthur, and she was already known to the household into which Clara had married. In the period following the wedding, Arthur Vance maintained a relationship with Rose Mercer, in open proximity to the marital household, and the evidence presented at the subsequent trial established that this domestic arrangement was apparent to those who had occasion to observe it. During the period of the marriage, Clara bore one child, a son registered under the name Edward James Vance. The child's precise birth date requires verification against the registers of the General Register Office, but his subsequent fate is established with high confidence in the sources. The infant's existence during the period before his removal from Clara's care provided her with her only close human connection within the Vance household. His removal and his placement under the custodianship of Daniel and Martha Vance deprived her of that bond, and further reduced the human contact she retained with the world outside her own circumstances. Clara's mother continued throughout the period following the marriage to seek access to her daughter. Her attempts were systematically refused. The testimony she gave at the subsequent inquest and at the trial described a succession of occasions on which she had presented herself at the address where Clara was kept and had been turned away. On some occasions by Arthur, and on others by members of the household acting at his direction. The exclusion of Mrs. Whitmore from any contact with her daughter was deliberate, consistent, and sustained over the full period of the events in question. It removed from Clara the one person who had both the motive and the knowledge of her circumstances to raise an effective alarm on her behalf. Arthur moved Clara away from Kingsford in the period following the marriage. By 1876, she had been removed to Hollow Mead Farm in the village of Fellbrook in the Northwell Downs, and placed under the daily care and custody of Daniel and Martha Vance. Daniel was Arthur's brother. Martha was born Martha Mercer, the sister of Rose Mercer. The farm at Fellbrook was remote. No railway served the village directly. The roads leading to it were rural and poorly maintained. The valley in which the farm sat was sparsely inhabited, and the farm itself was situated at a distance from the nearest neighbors. The selection of this particular location, removed from Kingsford and from the network of persons who might have inquired after Clara's welfare, was a matter addressed directly in the prosecution's case at trial. Daniel and Martha Vance were the persons most directly responsible for the conditions of Clara's daily existence at the farm. The room in which she was kept was on the upper floor of the farmhouse. Evidence presented at the trial described the conditions of that room and of Clara's physical state during the period of confinement in terms entered fully into the court record and reported at length in the national press. The bedding provided to her was inadequate. Her clothing was insufficient for the conditions. The food made available to her did not sustain her health. No medical professional was summoned to attend her at any point during the period of her confinement. Her physical condition deteriorated. The isolation of the farm from the ordinary network of social observation ensured that the nature of her circumstances remained unknown to any authority capable of acting upon it. The circumstances of Clara Vance's confinement at Fellbrook were entirely unknown to any official body at the time of her death. No complaint had been received. No medical professional had attended her. Her mother had been unable to reach her. The legal framework of the period provided no mechanism for identifying her situation in the absence of some external event that drew official attention. That event came in the second week of April, 1877. On the 8th of April, Clara's infant son, Edward, was admitted to St. Matthew's Hospital in Kingsford. He died there on that day. His death was attributed to neglect and malnutrition. He had been in the care of Daniel and Martha Vance during the period of his mother's confinement at the farm. He was, by the most reliable estimates, approximately 1 year of age. 4 days after the death of her son, on the 12th of April, 1877, the 4 defendants removed Clara Vance from Hollowmead Farm at Fellbrook and conveyed her to a lodging house in the district of Ashbourne. She was, at the time of this journey, in a state of extreme physical deterioration. Clara Vance died on the 12th of April, 1877, at the lodging house in Ashbourne, on the day of, or very shortly after, her arrival there. She was approximately 35 or 36 years of age. The precise address of the lodging house in Ashbourne was cited in contemporary newspaper accounts of the period, but has not been firmly established in available secondary sources. The prosecution's interpretation of this final journey was stated directly at trial. The defendants had been aware that Clara's death was imminent. They had removed her from the remote farmhouse where the sustained course of neglect had taken place, and conveyed her to an ordinary suburban address with no apparent history connected to those conditions, in order that her death might be attributed to natural causes, and the circumstances at Fellbrook remain undiscovered. A death in a suburban lodging house in Ashbourne, presented to a local physician as the natural death of an ill woman, might, in the ordinary course of events, have been certified without further inquiry. A death at the farm at Fellbrook, examined in the light of the room and the conditions to which the body had been subject, carried implications of a fundamentally different character. A local physician was summoned to the lodging house in Ashbourne on the 12th of April, 1877. The condition of Clara Vance's body was such that the examining doctor declined to issue a death certificate, attributing her death to natural causes. The body presented to his examination was that of a woman in a state of extreme emaciation. At the time of her death, Clara Vance weighed approximately 5 stone. Some sources give the figure as 5 stone and 4 pounds, and the slight variation in the cited weight does not affect the character of the finding. At either figure, the degree of physical wasting was severe and immediately apparent to any medical observer. Evidence of lice infestation was present on the body. The examining physician declined to issue a death certificate. His refusal was the act that brought the case to the attention of the Metropolitan Police. Officers were notified and attended the scene at Ashbourne. The condition of the body and the circumstances under which the woman had been brought to the lodging house on the day of her death were such that the matter was immediately treated as requiring formal investigation. Inquiries were begun into the circumstances of Clara Vance's recent life, and the name of the farm at Fellbrook in Northwell was established as the location where she had been living in the period before her death. Officers were dispatched to Hollowmead Farm. The investigation was formally opened. The Metropolitan Police and the local Northwell Constabulary both became involved, given the geographic spread of events. The death had occurred in Ashbourne on the Kingsford border, while the site of the prolonged confinement was at Fellbrook, within the county of Northwell. Statements were taken from those persons present at the lodging house at Ashbourne. The circumstances attending the arrival of Clara Vance, a visibly dying woman, at the address on the day of her death were recorded. The physician who had attended the scene provided his preliminary observations to the investigating officers. At Hollowmead Farm in Fellbrook, officers examined the premises. The room on the upper floor of the farmhouse in which Clara had been confined during the months preceding her death was inspected and its conditions documented. The physical state of that room corroborated the medical findings already made at Ashbourne. The bedding, the clothing available in the room, and the general conditions of the space in which a woman had lived for many months were recorded by the officers who attended the scene. The farm at Fellbrook was situated 12 to 15 miles from the center of Kingsford, accessible only by local road, and the distance from the metropolitan network of social oversight was not an incidental feature of the arrangements. The evidence gathered at Fellbrook was to form a significant part of the material placed before the jury at the subsequent trial. Witnesses were interviewed in the days following the discovery. The most significant witness account came from Clara's mother, Mrs. Whitmore. She was interviewed by the investigating officers and provided a detailed account of her repeated attempts to visit her daughter over the preceding months, and of the systematic manner in which those attempts had been refused. Her testimony established the deliberate character of the exclusion to which she had been subjected, a pattern of obstruction extending over the full period of Clara's confinement at Fellbrook. The specificity and consistency of her account were noted, and her evidence was to become, by the assessment of those present at the subsequent proceedings, one of the most affecting testimonies placed before the court. The four persons most immediately connected to Clara Vance's death were identified and arrested. Arthur Vance was Clara's husband, and the person primarily responsible for her removal from Kingsford and her placement at Fellbrook. Daniel Vance, his brother, and Martha Vance, Daniel's wife, were the persons who had been her immediate custodians at the farm. Rose Mercer, the sister of Martha and the companion of Arthur, had been present throughout the period of the domestic arrangements that had displaced Clara from her husband's household. All four were charged in connection with Clara's death. The defendants, in their initial statements, denied criminal intent. They maintained that Clara had been suffering from a natural disease, that her physical condition had been the product of illness rather than deliberate neglect, and that the care provided to her at Fellbrook had been appropriate to her circumstances. Arthur Vance, described in contemporary accounts as composed throughout the proceedings, maintained that his wife had received adequate care. Daniel and Martha Vance maintained that the conditions at the farm had been as good as her illness permitted. The investigation had now gathered its principal material from two locations: the lodging house in Ashbourne, where Clara Vance had died, and the farm at Fellbrook, where she had lived in the preceding months. The physical evidence at both locations corroborated the medical findings. The witness testimony, in particular the account provided by Clara's mother, supplied the human framework of the case. The question that remained for the formal proceedings was whether the circumstances constituted willful murder under English law, and whether the cause of death could be established to the standard required for a conviction. A post-mortem examination was conducted. The examination was carried out by medical professionals acting at the direction of the investigating authorities. The most prominent of the prosecution medical witnesses in this case was Dr. Edmund Graves, surgeon of Westminster Hospital. Graves was among the most experienced forensic practitioners in Kingsford at this period, and his engagement in the case reflected the gravity with which the investigating authorities regarded it. Additional medical witnesses participated in the examination and in the subsequent proceedings. The findings of the post-mortem examination were entered into the official record. The body of Clara Vance, as examined, presented the following features. The weight at death was approximately 5 stone, consistent with prolonged and severe starvation. The body showed evidence of lice infestation. The internal organs were consistent with the effects of prolonged deprivation. The brain was examined with particular care, and changes were noted. The prosecution's medical witnesses, led by Dr. Graves, concluded that these changes were consequent upon starvation, rather than upon any prior organic disease of independent causative significance. Their position was that the cause of Clara Vance's death was starvation and neglect, sustained deliberately over many months, and that no natural disease was present to a degree capable of independently accounting for her physical deterioration and death. The defense engaged its own medical witnesses. Their examination of the available evidence, including the post-mortem findings, produced a conclusion that differed materially from the prosecution's. The defense medical witnesses argued that the changes observed in the brain were consistent with tubercular meningitis, a disease of the central nervous system that in its advanced stages produces progressive physical wasting, cognitive deterioration, and death. On this interpretation, Clara Vance had been suffering from a naturally occurring fatal disease that would have caused her death regardless of how she had been treated. The neglect that could be proven against the defendants on this argument was not the legal cause of death. The cause of death was the disease. The distinction between the two interpretations was therefore not merely a matter of medical opinion, but a question of criminal liability. The central dispute of the post-mortem examination and of every formal proceeding that followed was this: whether the changes observed in Clara Vance's brain were the product of starvation or the evidence of an independently fatal disease. This dispute was not resolved at the time of the trial. The jury accepted the prosecution's account. The petition that followed the conviction rested upon the defense's account. The post-mortem findings were formally entered into the record, and the cause of death was recorded for the purposes of the prosecution as starvation and neglect. An inquest was convened in the days following the 12th of April, 1877. The proceedings were held in the Ashbourne area, in accordance with the standard practice of convening inquests at or near the location of the death. Testimony was taken under oath from a number of witnesses. The local physician, who had refused to certify the death, gave evidence regarding the condition of the body as he had found it, and his reasons for declining to issue a death certificate. Medical evidence regarding the post-mortem findings was set out in formal testimony. The conditions at Hollowmead Farm were described to the inquest by those with direct knowledge of them. Clara's mother, Mrs. Whitmore, gave evidence at the inquest. Her testimony described, in terms recorded and widely reported by the national press, the succession of occasions on which she had presented herself at the addresses where her daughter was held, and had been refused admittance. She described the period of exclusion from beginning to end, the early refusals, the subsequent visits that produced the same result, and her growing certainty that her daughter's circumstances were not as her son-in-law represented them to be. Her account of being turned away repeatedly from her own daughter's door, unable to ascertain whether Clara was alive or dead, formed the human center of the prosecution's narrative as it was assembled before the inquest jury. Evidence was also placed before the inquest concerning the death of the infant Edward at St. Matthew's Hospital on the 8th of April. The circumstances of his admission to the hospital, the condition in which he had been received there, and the cause attributed to his death, provided a separate but corroborating strand of evidence concerning the general standard of care exercised by those responsible for both mother and child during the period of the confinement. The jury at the inquest, having heard the medical evidence and the witness testimony, returned a verdict of willful murder against all four accused. The defendants were formally committed to stand trial at the Central Criminal Court. The committal was reported in the national press, and by the time the four defendants were formally bound over for trial, the broad outline of the case was known to a substantial portion of the newspaper-reading public. The Ashbourne mystery, as the press had taken to designating it, referring to the location of Clara Vance's death rather than the location of the crime, had established itself as one of the most discussed criminal cases in England in the months between the April death and the September trial. The trial of Arthur Vance, Daniel Vance, Martha Vance, and Rose Mercer commenced at the Central Criminal Court of Kingsford on the 19th of September, 1877. The presiding judge was Mr. Justice Fairchild. Sir Henry Fairchild was one of the most prominent figures on the criminal bench in Victorian England, and his handling of the proceedings attracted considerable commentary from the national press and from the legal profession throughout and after the trial. The prosecution was led by Mr. Charles Sterling, whose conduct of the case for the Crown is cited in multiple secondary sources. Each of the four defendants was separately represented by counsel. All four entered pleas of not guilty. The court was filled throughout the proceedings. The case had attracted sustained national attention since the death in April, and the September trial attracted a corresponding degree of public and press interest. The Times carried daily accounts of the proceedings, and its coverage was followed by provincial newspapers throughout England. The four defendants sat before the jury in a courtroom whose atmosphere, as described by the contemporary press, reflected both the gravity of the charge and the public familiarity with the principal facts that had already emerged from the inquest proceedings earlier in the year. The prosecution opened its case. Mr. Sterling addressed the jury with an account of the facts as the Crown proposed to establish them: the marriage, the inheritance, the confinement, the conditions at Fellbrook, and the death at Ashbourne. He characterized the case as one of deliberate and sustained murder, carried out not in a single violent act, but through the calculated withdrawal over a period of many months of the food, warmth, medical attention, and human contact required to sustain a vulnerable woman's life. The prosecution's argument was that the four defendants had together taken a woman of limited mental capacity, removed her from the only person capable of protecting her, confined her in conditions of extreme deprivation in a remote farmhouse, and left her to die. Medical evidence was presented by the prosecution in considerable detail. Dr. Edmund Graves and the other medical witnesses called by the Crown gave their testimony concerning the post-mortem examination and its findings. The weight of the body at death, approximately 5 stone, was placed before the jury as consistent with prolonged starvation of many months' duration. The condition of the body, the evidence of lice infestation, the state of the internal organs, and the changes observed in the brain were set out in the formal clinical language of forensic testimony. Dr. Graves and his colleagues maintained that the brain findings were consequent on starvation and were not evidence of any independently fatal organic disease. Their conclusion was that Clara Vance had died as a direct and proximate consequence of the neglect to which she had been subjected at Fellbrook. The evidence of Clara's mother was among the most significant testimonies placed before the jury. Mrs. Whitmore described, in terms that the press noted with considerable attention, the course of her attempts to see her daughter from the time of the marriage onward. She described the occasions on which she had come to the door of the Vance household and had been refused entry. She described the manner in which Arthur Vance and those acting at his direction had prevented her from making any independent assessment of her daughter's welfare. The exclusion she described was not a single refusal, but a sustained pattern of denial extending over months. A succession of visits that produced no admittance, messages that produced no response, and inquiries through every means available to a woman in her position that returned no reliable information about her daughter's condition or whereabouts. Her evidence supplied the human dimension that the medical testimony could not. Behind the door she could never open was a woman who had depended upon her mother for the whole of her adult life, and who was being held in conditions that produced, by April of 1877, the body that the physician at Ashbourne had refused to certify. Evidence was placed before the jury concerning Arthur Vance's financial motive. The inheritance that had passed to the household upon the marriage was put before the court. The open relationship with Rose Mercer maintained throughout the period of Clara's confinement was described. The arrangement by which Arthur had effectively established Rose Mercer as the operative center of his domestic life while Clara was held at Fellbrook was laid out for the jury in detail. The deliberate exclusion of Mrs. Whitmore, extending from the earliest weeks of the marriage through to Clara's death, was characterized by the prosecution as an integral part of a scheme that was criminal in its conception as well as its execution. The circumstances of the final removal to Ashbourne were addressed directly in the prosecution's case. The decision to convey a dying woman from a remote Northwell farmhouse to a suburban lodging house on the day of her death was characterized by the Crown as a calculated attempt to place her death at an address with no visible connection to the conditions that had caused it. The defendants had reason to know that Hollowmead Farm, if examined, would reveal conditions inconsistent with any account of adequate care. The lodging house in Ashbourne was intended to present the death as the natural end of a woman's illness, rather than the final stage of a prolonged and deliberate act of destruction. The death of the infant Edward, 4 days before his mother's own death, was placed before the jury as evidence of pattern. The child had been under the same general custodianship during the relevant period. His condition at admission to St. Matthew's Hospital and the cause attributed to his death were consistent with the same absence of adequate care that had produced Clara's condition. The 2 deaths, 4 days apart, were not presented to the jury as coincidence. The defense presented its case. Defense counsel for each of the 4 defendants argued, through their respective submissions and through the medical witnesses called on the defendant's behalf, that the cause of Clara Vance's death was tubercular meningitis and not starvation. The defense medical witnesses gave their evidence concerning the brain findings and maintained that the changes observed were consistent with tubercular disease, that the degree of wasting presented by the body was explicable on the basis of the disease without any reference to deliberate neglect, and that if the cause of death was a naturally occurring disease, the defendants had not committed murder. Their conduct, whatever its character, was not the proximate cause of death. A verdict of willful murder could not stand where death would have occurred in any event. Defense counsel urged upon the jury that the evidence of deliberate intent required to support a verdict of willful murder had not been established. The conditions at Fellbrook, it was argued, reflected limited means and limited understanding, rather than a calculated program of destruction. The removal to Ashbourne was characterized as an ordinary domestic arrangement, rather than an attempt to conceal a crime. Mr. Justice Fairchild summed up the evidence to the jury. His charge addressed both the factual evidence and the medical dispute at the center of the case. Fairchild was, by the standards of his time, an authoritative figure on the criminal bench, and his handling of contested medical testimony in a murder trial was observed closely by the press and by members of the legal profession present in court. The weight to be given to the competing medical testimonies was set out for the jury in terms that subsequent commentary described as firmly directed. The direction was widely understood at the time to favor the prosecution's account of the medical evidence. The jury retired to deliberate and returned its verdict. All 4 defendants were found guilty of willful murder. The verdict was unanimous in its reach across the dock. Arthur Vance, Daniel Vance, Martha Vance, and Rose Mercer were each convicted of the willful murder of Clara Vance. The verdict was entered in the record of the Central Criminal Court. The prosecution's case, built upon the medical evidence of Dr. Graves and his colleagues, the testimony of Clara's mother, the physical evidence gathered at Fellbrook, and the circumstances of the final removal to Ashbourne, had been accepted in full by the jury. The conviction of all 4 defendants on the most serious criminal charge available under English law reflected the jury's determination of the facts. The legal consequence of that determination was now to be pronounced by the court. The court proceeded to sentencing. Mr. Justice Fairchild addressed the 4 convicted defendants. The sentence prescribed under English law for willful murder was death by hanging, and Fairchild imposed that sentence upon each of the 4. All 4 defendants were condemned to die. The public reaction to the verdicts and sentences was reported as one of general approval. The case had generated sustained national sympathy for Clara Vance throughout its coverage, and the guilty verdicts were received by the mainstream press as the appropriate conclusion of a case whose facts had by September been widely known for months. The outrage that had attended the disclosure of Clara's physical condition and the manner of her confinement found its formal expression in the verdict. The 4 defendants were removed from the dock and held in custody, awaiting execution. The period between sentence and execution in Victorian criminal practice was typically brief. A condemned person might expect, in the ordinary course, to hang within a matter of weeks of the sentence being pronounced. The mechanism available to those seeking relief from a death sentence was a petition to the Home Secretary, who exercised the Crown's prerogative of mercy and held the power to commute a sentence to a lesser punishment. Such petitions were commonly submitted. Their success depended on the grounds advanced and the weight assigned to them by the Secretary of State. The petition submitted on behalf of the 4 Vance defendants was unusual in its character and in its source. The grounds advanced were not the customary grounds of prior good character, extenuating circumstances, or doubt about the identity of the perpetrators. The grounds were medical. The claim advanced to the Home Secretary was that the post-mortem findings had been misinterpreted by the prosecution's witnesses, that the true cause of Clara Vance's death was tubercular meningitis, and that in consequence, the 4 persons condemned to death had not, in law, committed the murder of which they had been convicted. These grounds were advanced not solely by the defendants or their legal representatives, but by a substantial body of the organized medical profession of England. The petition that reached the Home Secretary in the autumn of 1877 was remarkable in its scale and its character. The number of medical practitioners who appended their signatures to the document is cited in secondary sources as exceeding 400, a figure representing a very substantial body of organized professional opinion within the Kingsford medical world and beyond. Among those involved in the petition were senior physicians attached to the principal teaching hospitals of the capital. The petition argued that the post-mortem findings in the case of Clara Vance were consistent with tubercular meningitis rather than starvation as the primary cause of death. That this interpretation had been advanced at trial by the defense medical witnesses and had not been accepted by the prosecution or the jury, and that the convictions, consequently, rested on a medical conclusion that was, in the view of the signatories, erroneous. The petition was addressed to the Home Secretary and presented through the formal channel of the prerogative of mercy. It did not seek a new trial. It did not ask the courts to review their decision. It asked the executive branch of government to exercise its constitutional power to commute the death sentences on the ground that the medical foundation of the convictions was insecure. The Home Secretary, responsible for considering the petition, was Henry Ashcroft, who held that office in the conservative administration of Benjamin Disraeli during the years 1874 to 1880. Ashcroft was a lawyer and administrator of considerable experience. the Vance petition was not an ordinary capital petition. It advanced a technical argument about the interpretation of specific pathological findings supported by the professional authority of several hundred practitioners, and it required the Home Secretary to form a view on a dispute between medical witnesses whose disagreement had already been placed before a jury and decided against the defense. Ashcroft commuted all 4 death sentences to penal servitude. The commutation was announced in October of 1877. The public reaction to the commutation was immediate, sustained, and hostile. The Times, which had covered the trial and the verdict with approval, was forceful in its condemnation of the Home Secretary's decision. The central grievance expressed in the press was direct. A jury had heard all the evidence in the case, including the evidence of the defense medical witnesses who had advanced the tubercular meningitis argument and had returned a verdict of guilty. The same argument that the jury had rejected in the courtroom had been accepted at the Home Office. The medical profession had achieved through the petition what 4 defense barristers had been unable to achieve at trial. The legal commentary that followed the commutation raised questions of principle as well as of outcome. The power of the Home Secretary to commute a sentence was constitutionally unimpeachable. It was the ordinary exercise of the prerogative of mercy vested in the Crown. The objection that was articulated in the legal press and in correspondence to the national newspapers was not that the power had been improperly exercised, but that it had been exercised in a manner that effectively substituted professional medical opinion for the verdict of a properly constituted jury. Mr. Justice Fairchild had directed the jury on the medical evidence at length and with apparent clarity. The jury had deliberated and returned its verdict. The court had sentenced. That this sequence had been undone by a petition signed by practitioners who had not been in the courtroom, who had not heard the evidence tested by cross-examination, and who had not accepted any of the procedural obligations of expert witnesses, was regarded by a significant body of legal opinion as an outcome inconsistent with the proper operation of criminal justice. The medical profession, for its part, maintained that the petition was not an act of self-interest or of institutional solidarity with colleagues who had given evidence for the defense. It was, the signatories argued, an act of professional duty. The brain findings in the post-mortem, examined against the standards of contemporary pathological knowledge, indicated tubercular meningitis. The possibility that 4 persons had been condemned to death on the basis of a medical conclusion that was erroneous created an obligation on those with the relevant expertise to make the matter known, through whatever formal channel was available to them. The petition to the Home Secretary was the appropriate channel. The professional duty had been performed. This dispute between those who regarded the commutation as a miscarriage and those who regarded it as a correction was not resolved in the weeks and months following the announcement. It continued in the press, in the medical journals, and in the legal periodicals through the autumn and winter of 1877 and beyond. The Lancet and the British Medical Journal both carried commentary on the matter at the time of the original proceedings and in the period following the commutation. The public debate exposed a tension in the Victorian criminal justice framework between the authority of the jury as the recognized arbiter of fact and the growing authority of specialist expertise as the acknowledged arbiter of technical questions. Neither of these sources of authority had an unambiguous claim to priority in a case where they had reached opposite conclusions. The Vance commutation did not resolve this tension. It placed the tension in full public view. The 4 convicted persons entered the prison system following the commutation of their sentences. Penal servitude in the Victorian system involved confinement in the convict prisons together with compulsory labor, and the conditions of that confinement were substantially harsher than those of ordinary imprisonment. No pardon was ever issued in this case. No formal exoneration followed. The commutation was an act of mercy, not a legal reversal. It acknowledged the possibility that the medical basis of the conviction was contested. It did not find that the conviction was wrong. The record of the Central Criminal Court continued to show 4 persons convicted of the willful murder of Clara Vance. The legal status of the case is that of a conviction that was commuted but not overturned, a verdict that stood but was not carried into execution, a record that remained as the courts had entered it, while the sentence was replaced. The case attracted and retained attention in the press and in crime literature, both during the proceedings and in the decades that followed. The designation, the Ashbourne Mystery, had been adopted by the national press by the time of the trial. It derived from the location of Clara Vance's death, rather than from the location of the crime at Fellbrook, and it persisted in Victorian and Edwardian crime writing as the standard name by which the case was identified. H.B. Irving included a treatment of the case in his 1918 work on notable criminal cases. The case appears in works on Victorian forensic medicine, particularly in discussions of the development of expert medical testimony in criminal proceedings, where it functions as a significant episode in the institutional history of the relationship between medicine and the law. The figure of Clara's mother occupied a particular place in the public commentary that surrounded the case throughout its progress. Her testimony at the inquest and at the trial, and the image it conveyed of a woman systematically excluded from access to a vulnerable daughter by a calculating son-in-law, was the element of the case that most directly engaged popular sympathy. Press commentary returned to this figure at each stage of the proceedings. The specific character of her experience was understood clearly by those who followed the case. A woman who had served as the practical guardian of her daughter throughout Clara's adult life had been deliberately and completely cut off from any knowledge of or access to her daughter for the full duration of the crime, and her daughter had died before the exclusion could be overcome. The historical significance of the Clara Vance case extends across several distinct but connected areas of Victorian social and legal history, and the case has been cited in the relevant literature as a significant episode in each of them. The case contributed directly to public discussion about the legal position of persons of limited mental capacity who had not been formally certified under the Lunacy Acts. Clara Whitmore had been, by the account of all who knew her, a woman whose limitations were apparent to those in her social circle. The law had provided no mechanism for preventing her marriage to a man who was, as the prosecution established, motivated primarily by access to her inheritance. She occupied a position in the practical operation of Victorian law that was entirely without formal protection. Not certified as a lunatic, and therefore without the protections available to persons formally adjudicated as of unsound mind. Not possessed, in any practical sense, of the capacity for self-protection that the ordinary presumptions of the law attributed to an adult. The Lunacy Acts provided for the appointment of a committee of the person in cases of certified lunacy, with formal oversight of the certified person's affairs and welfare. For those who, like Clara, were understood by everyone in their social circle to require protection, but had never been brought through the process of formal certification, these provisions were entirely unavailable. Her mother had served as her informal guardian. The law had no machinery to formalize or reinforce that role in the face of a husband who chose to disregard it. The Vance case illustrated this gap in the legislative framework with a completeness and with consequences that the public and the press did not set aside quickly. And the case contributed to the continuing pressure for statutory reform of the law governing the protection of vulnerable adults. The commutation controversy contributed separately to Victorian debate about the proper weight to be accorded to expert medical witnesses in criminal proceedings. This debate ran through the later Victorian and Edwardian periods, with increasing persistence as the range and complexity of technical matters brought before criminal courts expanded, and the capacity of juries to evaluate competing expert claims was increasingly questioned by observers from both the legal and the medical professions. The Vance case provided a particularly clear and publicly visible instance of the central difficulty. Two groups of qualified practitioners had examined the same post-mortem findings and reached directly opposite conclusions about the cause of death. A jury of laypersons, directed by an experienced judge, had resolved the conflict in favor of the prosecution's witnesses. Several hundred members of the medical profession had resolved it in favor of the defense. The Home Secretary had resolved it in favor of the profession. Each of these resolutions had a procedural basis. The jury was the constitutionally recognized arbiter of fact in a criminal trial. The judge had directed it with apparent clarity. The verdict it returned was the product of due legal process. The medical petition represented a body of professional opinion that had not been tested by cross-examination, had not been required to demonstrate its reasoning before a tribunal, and was not subject to any procedural constraint. The Home Secretary had the power to act on such a petition. The exercise of that power was not unlawful. But the outcome, which substituted an unexamined professional opinion for a tested jury verdict, was not one that the legal community or the general public found straightforwardly satisfactory. The case entered the literature of Victorian forensic medicine and Victorian legal history as a marker of the point at which the established mechanisms of proof became inadequate to resolve disputes of this kind. The case also illustrated with considerable sharpness the limits of the available institutional machinery for protecting persons in Clara Vance's position once the abuse of their circumstances had begun. The investigating officers had no knowledge of the conditions at Fellbrook until after Clara's death. Her mother's repeated attempts to reach her produced no official response, because no complaint had been formally received by any authority. The mechanisms by which persons in the custody of a husband could be reached by outside observers were, in the 1870s, narrow and largely dependent on the goodwill of the persons holding custody. The Married Women's Property Act of 1870 had begun the process of reform that would eventually alter the legal position of married women in England. But the practical protections available to a woman of Clara's circumstances within an established marriage were, at the time of her confinement, extremely limited. The case contributed to the discussion of what further legal mechanisms might be required to address the situation of vulnerable persons held in conditions the law had no ready means to inspect. The primary documentation of the Clara Vance case survives in several locations. The trial transcript is preserved in the criminal court proceedings online, which hold the records of proceedings at the Central Criminal Court from 1674 through 1913, and contain the full record of the September 1877 proceedings, including the composition of counsel, the testimony of witnesses, and the judge's charge to the jury. Home Office files at the National Archives hold the commutation correspondence, the medical petition itself, and the documentation of the Home Secretary's decision. Prison records in the PCOM series at the National Archives hold the documentation of the post-commutation imprisonment of the 4 defendants. Contemporary coverage in The Times constitutes the most extensive running account of the case, from the inquest in April through the commutation controversy in October and beyond. The professional medical journals, in particular The Lancet and the British Medical Journal, carry the record of the intra-professional debate as it was conducted in the medical press at the time. What has not survived is Clara Vance's own account of her experience. She died at the lodging house in Ashbourne on the 12th of April, 1877, without leaving any documented testimony about the period of her confinement at Fellbrook, about the conditions in which she had been held, about what she had known or understood of her own circumstances, or about any aspect of the events that surrounded her. the conditions in which she had lived during the period of her confinement, the treatment she had received or had been denied, and the quality of her daily existence at Hollow Mead Farm can be reconstructed only from the testimony of those who had direct or indirect knowledge of it, given under oath at the inquest and at the Central Criminal Court. The evidence of her physical condition at death, the weight of approximately 5 stone, the state of the room, the body's condition as documented in the post-mortem record, speaks of the conditions of her confinement without providing the account that she herself was never in a position to give. Her own voice is absent from every document in the case record. The case of Clara Vance is a case in which the central figure speaks only through the consequences of what was done to her, and through the testimony of the one person who had tried without success to reach her.